This video is designed to educate you about the difficult situation of an eviction and help you navigate the process, including a trip to eviction court. Landlord-tenant laws change county by county, so this video is only meant to provide general information. Before you take any action or rely on any information in this video, it is highly recommended that you consult an attorney or contact the legal aid office. Eviction is legally known as forcible detainer. It is a legal process a landlord must go through to remove a tenant from rental property. A tenant can be evicted for failure to pay rent, violation of the lease agreement, or because the lease is expired. A landlord can only evict a tenant if he has gone through the correct legal process, which will be discussed later in this video. Since a landlord cannot evict you without going through the correct legal process, if a landlord tries to evict you without a court order, you should immediately call the police and then call an attorney. Before your landlord could even file for an eviction in court, he must give you a notice and an opportunity to pay your rent within 7 days of the notice. During those 7 days, he is required to accept your rent if paid in full, including late fees. If he accepts any money from you at any time during those 7 days, even if it is less than the amount you owe, he must give you another notice and another 7-day opportunity to pay your rent in full. Basically, the landlord accepting a portion of what you owe in that 7-day period starts the 7-day process all over again. After the 7 days have expired, the landlord is no longer required to accept any money from you. Even though the acceptance of part of the money from you prevents him from being able to evict you, the landlord could still sue you in small claims court for the remaining amount. If your landlord is evicting you for some other reason than paying the rent, he must give you 14 days to fix the violation he's accusing you of. But he is not required to give you the 14-day opportunity if you have committed the same behavior within the past 6 months. Also, if your landlord accepts any rent from you after he knows about the violation, he cannot evict you for that violation. If your landlord is trying to evict you, you will know because he will already have provided you a written notice. When he goes to court to start the legal process, you will receive a petition for and writ of forcible entry and detainer. The petition will tell you the reason that the landlord is evicting you, as well as when and where you need to go to court. You must show up to court for your eviction hearing. First, if you do not show up to court, you will automatically be evicted. Second, you have a right to defend yourself at court. You have the right to bring witnesses and other evidence, such as photographs, letters, and rent receipts to court. If your witnesses are unwilling to come to court to help you, you can subpoena them. A subpoena is a tool used by the court to make people come testify. You can get a subpoena from the court clerk, and it is important that you fill it out and get it to the witness as quickly as possible. When you go to eviction court, you should arrive early because you do not want to be late. You should allow extra time and bring money for parking, allow time to get through courthouse security, and allow time to find the courtroom. You should turn off all cell phones and electronic devices before entering the courtroom. You should also dress nicely, as if you're going to a job interview. You should never approach the judge unless he or she asks you to, and you should address the judge as Your Honor. The judge will first hear the landlord's case and will then ask you to respond. This is your opportunity to raise potential defenses, as well as to ask the judge to look at your evidence. Your evidence is any witness you have brought or subpoenaed, pictures you have taken, letters, and rent receipts. The main defense that tenants are likely to be able to use in eviction court is if the tenant can show that they have fixed the problem. For example, if the landlord states in the petition that the tenant is $1,400 behind on rent, the tenant can bring to court rent receipts showing he has paid up the $1,400 in rent that he was behind. A tenant might also be able to show that the only reason the landlord is evicting them is in retaliation. You can prove retaliation only in the following 3 ways. First, if the tenant has complained to an agency, like the health department, because of repairs needed to the apartment. Second, if a tenant has complained to the landlord of any violation of health and safety. And third, if the tenant has joined or organized a tenants union. If any of these actions by the tenant angered the landlord to the point that he decided to get back at the tenant by evicting him, this would be an example of retaliation. Remember, retaliation is hard to prove and the eviction must occur within 1 year of the tenant's actions. However, if you are being evicted for non-payment of rent, retaliation is not an option. If you lose an eviction court, you have 7 days to take action. Your options are: 1. Try to work something out with your landlord. 2. Appeal your case. Or 3. Move out within the 7 days. If you cannot move out within those 7 days, the landlord will contact the sheriff's office to schedule a set-out date. A set-out is when the landlord removes your property from the residence and puts it in the street. The sheriff will be there only to keep the peace. The set-out must be supervised by a sheriff, and you will get notice of the set-out date prior to that date. If your landlord tries to remove your belongings without the sheriff present, it is illegal and you should call the police. It is always best to move out voluntarily before a set-out to avoid loss and damage to your property. As we have already discussed, it is illegal for a landlord to evict you without going through the proper court process. It is also illegal for a landlord to set out your belongings without a court-ordered eviction and the presence of a sheriff. Another tool that landlords might use to illegally try to evict you is a lockout. A lockout is just what it sounds like. The landlord locks you out of your residence. You should not try breaking into the residence because that could cause damage to the landlord's property, which you would be responsible for. Instead, you should call the police immediately, and they can require the landlord to allow you into your residence. A landlord might also try to evict you by disconnecting essential services such as water, gas, or electric. If any of these illegal evictions occur, you might be able to sue the landlord, but it might be best just to move out. You should get an attorney or contact legal aid for advice regarding your options. This video educated you about evictions, illegal evictions, and the court process. Self-help forms are available at Legal Aid and at kyjustice.org/legal information. These forms can be used for certain stages of the eviction process and for communicating with your landlord. If you need additional assistance, contact an attorney or your local legal aid office for advice.